So welcome everyone. My name is Julia Dehm. I'm a senior lecturer in law at Trobe University, and I want to welcome you all to this webinar about investor-state dispute settlement, or ISDS. ISDS is a system of corporate rights to sue governments that are found in some trade and investment agreements, and they're used against government action on climate policy or other public interest and health policies. I also want to acknowledge the traditional custodians of the land on which I am, the Wurundjeri people of the Kulin Nation, and to acknowledge that all of us are meeting on Indigenous land, and to pay my respect to elders past and present, and to any Indigenous people joining us here today. And I want to note too that mining companies have successfully used ISDS to claim tens of millions in compensation for laws which protect Indigenous rights to traditional lands. For example, the Bear Creek mining case that was brought against Peru. Before turning to our speakers, a quick housekeeping matter that if you haven't already, please do mute your microphones and stay muted while the speakers are speaking to minimise any background noise. So we have some wonderful speakers today. Our first speaker is Dr. Patrica Ranald, who's the AFTINET convener and an honorary research associate at the University of Sydney. She will give some background on ISDS and explain how Clive Palmer and other fossil fuel companies are using it to claim compensation from governments against policies directed to taking action on climate change. Over to you, Pat.
Thanks for that introduction, and I also acknowledge that we're on Indigenous land. AFTINET is a network of 60 community organisations advocating for fair trade based on human rights, labour rights and environmental standards. Investor-State Dispute Settlement, or ISDS, is a set of legally binding rules found only in some trade agreements which allow foreign investors to claim billions of dollars in compensation from national governments if they can convince an international tribunal that a change in law or policy has broken these rules and will reduce their future profits. ISDS comes from the post-World War II decolonisation period and was originally designed to compensate former colonial investors for expropriation of actual property through investment treaties and broader trade agreements. But the ISDS system has developed rules like indirect expropriation and fair and equitable treatment, which do not involve taking of property and do not exist in national legal systems. Investors can claim that a change in law or policy has reduced their expected future profits and or that they were not consulted fairly about the change and or that it did not meet their expectations of regulation at the time of their investment. There is a global ISDS legal industry which advises investors about registering companies in countries with ISDS agreements so that they can maximise their potential cases. Unlike national legal systems in which judges must cease to be practising lawyers, ISDS tribunals don't have independent judges but are panels of temporary arbitrators who can continue to be practising lawyers with potential conflicts of interest. ISDS also has no precedents or appeals, which in national systems are intended to ensure consistency of decisions. So all of this means that the tribunals can pay more attention to compensating investors than to whether the change or law in policy is in the public interest. Most claims are actually against developing countries, some with crippling compensation of billions of dollars, amounting to a substantial proportion of their domestic budgets, and Kate's going to talk about this. There are now increasing numbers of claims against industrialised countries like Australia. There have been growing numbers of claims against public interest regulation. So these include tobacco regulation, medicine patents, environmental regulation, Indigenous land rights, and even regulation of the minimum wage. More recently, there have been many claims by fossil fuel companies against government action to address the climate crisis, which Kyla will discuss. So where does Clive Palmer fit in? Clive Palmer, an Australian billionaire, has registered his mining company in Singapore and is claiming to be a Singaporean investor. He's using ISDS rules in 2 Australian trade agreements with ASEAN and with Singapore to claim a total of $110 billion in compensation from the federal government. This is because a Queensland court refused his coal mining licences for environmental reasons, including their contribution to carbon emissions. Briana will explain why this was an important decision for the environment. Even if Palmer's claims are not successful, the government will have to spend years and tens of millions defending them. The Philip Morris Tobacco Company claim against Australia's 2012 plain packaging law took almost 5 years and cost Australia $12 million in legal fees. Well, what can we do about it? We are part of a global civil society campaign on ISDS, and we're having victories. Leading developing countries like South Africa and Brazil have withdrawn or refused ISDS arrangements, have several Latin American countries. There's bipartisan opposition to ISDS in the United States. The 27 European countries and the United Kingdom have decided to withdraw from the Energy Charter Treaty because its ISDS rules were being used against them, against their climate change policies. And ISDS has also been excluded from recent Australian agreements with the UK and the EU and from the 15-member Asia-Pacific Regional Comprehensive Economic Partnership. So we are winning some victories. Even a former cheerleader for ISDS from the International Chamber of Commerce said recently that defenders of ISDS had, quote, lost the battle of public opinion and the battle for legitimacy. The Labor government does have a policy against ISDS in new agreements and to review and remove it from existing agreements. We are campaigning to speed up the removal of ISDS in existing agreements to prevent more cases like Palmer's. We need to keep up and publicise this fight to counter the influence of fossil fuel companies and other international companies who are the main defenders of ISDS. So we're asking you to sign and share our petition to speed up the removal of ISDS in existing trade agreements. And the link, I think Peter's putting it in the chat. And we're also planning an open letter to the Trade Minister from Academics, which will be explained later, and an open letter signed by many civil society organisations. And if you do want more details about the cases and other aspects of ISDS, you can read our briefing paper. The link for that is also in the chat. So thanks very much.
Thanks so much, Pat, for that overview, and those resources are available in the chat, so please do follow those links. Our second speaker is Briana Collins, who's a solicitor at the Environmental Defenders Office. She acted for the Bimblebox Alliance, who were objectors to the Waratah Coal Galilee Coal Project over 6 different court cases from 2020 to 2022, which culminated in a recommendation for refusal of the project by the Queensland Land Court and a final refusal by the Queensland Government. He will explain the importance of the Queensland Land Court decision to refuse environmental permits for Palmer's Waratah coal mine for the environment and for climate change policy. Over to you, Briana.
Thanks very much, Julia, and thanks everyone for having me today. I'm on Yagara and Turrbal country in Meandrin, also known as Brisbane, and I'd also like to acknowledge that sovereignty was never ceded here, and the laws that I work within as a lawyer are not the legitimate nor the first laws in this country. So in my introduction, thank you very much, Julia mentioned that I was going to be talking about the significance of this particular case, which saw the refusal by President Kingham of the Mining Lease and Environmental Authority for the Galilee Coal Project. But I actually am going to go a little off script and speak about the insignificance of that case, because I think in the context of this talk, it's important to highlight the insignificance insofar as to counter the claims actually that Palmer has been using to pursue litigation in this matter, that this case was somehow ideologically charged or anti-coal. And I actually think President Kingham, who was the judge in this particular case, summed it up for us in the very first line of her judgment, which I think potentially demonstrates some level of foreboding that she might have had about the claims that were to come. But she said, and I quote, "This case is not about whether any new coal mine should be approved. It is about whether this coal mine should be approved on its merits." So in very simple terms, this case was a merits review, which is an inquiry into the pros and cons of the mine. And so it was significant in its outcome, and I don't want to understate how significant it was to many people, because it was the first coal mine in Queensland to be rejected on human rights and climate change grounds. But I think it's important to note in the context of this discussion that we're having that these were just two of many issues specific to this particular mine that led to the ultimate recommendation of refusal given by President Kingham. Because quite simply, the benefits of the mine, which are usually described as economic benefits, could not outweigh the detriments that it would cause to the environment and to human rights. And in some ways, the mine was actually more exceptional than the case itself. And there are a couple of reasons for that I can explain. So firstly, the mine, Waratah Coal, Waratah Coal was a private company. So it was important to the case that Clive Palmer was going to be the sole beneficiary of the profits of this particular mine, which is quite unique because often when we're talking about the economic benefits, we're talking about the economic benefits to the community via shareholders. In this case, only Clive Palmer was going to profit from this mine. The other thing to be aware of is that the economic benefits of this mine were uncertain because they had been modeled on an unrealistic prediction of the value of coal until 2050. And a big one that's really important to our clients, the Bimblebox Alliance, as separate from our clients' Youth Verdict, who fought largely on First Nations rights grounds. The mine was proposed to be on top of a nature refuge that had been declared protected in perpetuity by the federal government, which was quite unique. So because of the uncertainty of the benefits of the mine and the relative certainty of the harm that would be caused, not just because of climate change, but also because of issues like biodiversity and subsidence, the court found that the approval would not be in the public interest. So finally, I think not of the least importance to what I have called the insignificance of this particular finding is that the Land Court's judgment was a recommendation and they were acting in an administrative capacity, which means that ultimately it was the democratically elected Queensland government via the Department of Resources and the Department of Environment and Science who made that ultimate decision to refuse the mine. So I think it's within that couching that Palmer's challenges should be understood, that this proposal was objected to by the objectors and was ultimately decided by the court and then the government on a huge range of issues, including climate change and human rights, but certainly not limited to those. And that's all from me for now, but I'm happy to take questions at the end if we have time as well.
Many thanks, Briana. That was incredibly helpful, that summary and your framing of the case. Our next speaker is Professor Tienhaara, who's the Research Chair, Economy and Environment at Queen's University in Ontario. She's the author of several studies about the rising number of cases by fossil fuel companies against governments' climate change policies, and also the various response and reform efforts underway by governments and international organisations like the United Nations and the OECD. Over to you, Kyla.
Great, thanks very much for that. I would like to acknowledge that I am speaking to you from the traditional territory of the Anishinaabe and Haudenosaunee peoples. And I would like to also thank the organizers for the opportunity to speak and for everybody that's attending in the audience. I also want to apologize in advance if my voice fails me. I have a bit of a cold, but hopefully the tea will get me through. So I'm going to zoom us out a little bit because although the Clive Palmer cases are particularly bonkers, and you can quote me on that, they're also part of a broader trend that we can see happening around the world. So just to start with some numbers, fossil fuel, and these are all, I should note, from a 2023 report from the International Institute for Environment and Development, and the link is there at the bottom. Fossil fuel investors are really big users of the ISDS system. 1 out of every 5 cases is related to a fossil fuel project. So to date, there's been at least 349. And many of these cases are quite recent, and so they're still pending conclusion. Now, I should note that most of those cases are not directly related to climate policies. I will get to the climate cases in a minute, but this demonstrates that this sector is really adept at using this system and is quite happy to resort to it. And many of these cases also do have a lot of implications for other areas of public policy, like taxation. And so I don't know if Australia has been thinking about a windfall tax, but there's been some cases related to that recently. Fossil fuel investors are also really big winners in the system. So if we look at the cases that have made it to the merit stage, so they haven't lost at the jurisdiction, they have won 75%, which is a lot higher actually than across all sectors. And they've won a lot of money so far, at least 82.8 billion US dollars in damages. And this, of course, is money that they then can be reinvested in further fossil fuel projects, which of course further exacerbates the climate crisis. Okay, so now let's look specifically at some cases that I like to call climate relevant, because not all of them are related directly to climate policy, but nevertheless, these cases all demonstrate what might happen if states were to enact similar policies for climate reasons. For example, a ban on gas fracking that sparked the Lone Pine dispute here in Canada was primarily motivated by the desire to protect a sensitive ecosystem. I'm just going to mute this person.
I'll try to.
Yeah, I just did. And
Thanks.
then obviously, so this was to protect an ecosystem, but obviously a lot of governments are seeing the need to potentially ban new fossil fuel projects for climate reasons. Now, I would point out that the state, Canada, did actually win this particular case, but I would also highlight that the tribunal's reasoning was very narrow. So unfortunately, I don't think the outcome should actually give any comfort to other governments that are contemplating that kind of action. Then we have two ongoing cases against the US over the cancellation of the Keystone XL pipeline. This was an incredibly controversial project that would have taken oil from the Alberta tar sands across several US states and down to refineries in the Gulf Coast. President Obama canceled it in 2015, citing the need to demonstrate climate leadership. This was right before the Paris Agreement was signed. The company then filed a $15 billion ISDS case. Then we had Trump come in, allowed the project to move ahead, and then they dropped the case. And we have Biden elected, and the project hadn't proceeded that far because of other legal obstacles, but he then canceled the project, and the company again is now suing for $15 billion. Interestingly, the province of Alberta is also suing through a corporation that they own because they made a very poor decision to invest a lot of public money in the project. Rockhopper case, it was one about a ban on offshore oil production. Italy lost that case and had to compensate the investor more than 250 million euros, even though the company was only at the exploration phase and had spent a fraction of that at the time of the ban. That company is now reinvesting that windfall in oil projects in the Falkland Islands. So you could say that Italy is being forced to subsidize oil extraction in the Falklands, which is of course not compatible with a 1.5 or even 2-degree pathway. So I don't have time to go into all of these cases. I would just also highlight that there are 4 that are related to compensation payouts for governments phasing out coal power. And I do think that that's an area where there's a potential for a lot more disputes to arise. I can talk about these more in the Q&A if anyone is interested. So what can we conclude from this rising number of cases? Well, the UN Rapporteur on Human Rights and the Environment has considered them as well as other evidence very carefully and has argued that investor-state dispute settlement has become a major obstacle to the urgent actions needed to address the planetary, environmental, and human rights crises. Governments also seem to be increasingly aware that there's potential for conflict between investment treaties and climate measures. This graph is from a presentation by the OECD Secretariat last October. They conducted a survey on this topic, and a majority of the states that responded felt that there was not sufficient policy space available to protect climate policy in current investment treaties. So if the UN knows this, the OECD knows this, what is being done about it? Well, there are a number of different proposals and actions that have been put forward. One approach that has been put forward by some academics, as well as the OECD Secretariat, is to carve out fossil fuels, or to carve out climate policy, or to carve out both from investment treaty coverage. This is very similar to what Australia has done with carving out tobacco from its treaties following the Philip Morris dispute. In June 2022, the members of the Energy Charter Treaty, or ECT, which is a very big investment treaty that includes mainly European countries, but also Japan and some others, announced that they had come up with a deal to modernize the agreement, and this included an optional fossil fuel carve-out. The modernized deal has yet to be adopted because many countries have decided to quit the agreement instead. So that is another approach that is being taken, leaving these treaties altogether. I am a big proponent of this approach because there are limitations to carve-outs, which again, I'm happy to discuss in the Q&A. And importantly, there is no proven public benefit to these treaties. So why are we keeping them? However, I would acknowledge that one drawback of the exit strategy is that most investment treaties have what are called sunset or survival clauses, which means that if not everyone agrees to terminate the treaty, they will continue to provide protection for existing investments for 10 to 20 years. The EU is currently working on how to get out of this sunset clause in the ECT, so it's worth keeping an eye on what happens there. Another possibility is to renegotiate treaties to remove ISDS. The North American Free Trade Agreement, or NAFTA, was renegotiated a few years ago, and the ISDS clauses between Canada and the US were completely removed. Mexico, unfortunately, still has some exposure, although it's more limited than it was before. And then New Zealand's approach with the Comprehensive and Progressive Agreement for a Trans-Pacific Partnership, or CPP, was to sign side letters with willing parties to rule out ISDS. And notably, Australia also did this, for example, with the UK that recently joined the CPTPP. Also worth noting is that just a few weeks ago, Ecuador had a referendum where the public overwhelmingly voted to keep a clause in its constitution that bans the government from entering into any ISDS arrangements. Okay, so to sum up, ISDS is an obstacle to climate action. The threat of arbitration can delay action, and large awards can make the energy transition much more costly. That's the bad news. The good news is that states made these treaties and they can also unmake them. There are some challenges associated with this, but coordinated action can overcome these challenges. As a dual Canadian-Australian citizen, I would of course be overjoyed if Australia were to take a leadership role in bringing together like-minded states to achieve this. Thank you very much.
Thanks so much, Kyla. Our next speaker is the Honourable Josh Wilson, who's the Federal Labor member for Fremantle and Chair of the Joint Standing Committee on Treaties. He will discuss ISDS from a parliamentary perspective and its implications for democracy. Thanks, Josh.
Thanks, Julia, and all of today's speakers, Kyla, Briana and Kate. Special thanks to Dr. Ranald and all who are part of the vital work that AFTINET does. I'm coming to you from Fremantle, or Wallula, which is Whadjuk Noongar Budja, the lands of the Whadjuk Noongar people. It always has been, always will be Aboriginal land, and it's a privilege to be part of the webinar and present a current parliamentary perspective. My first sharp awareness of ISDS was in relation to the Philip Morris challenge to the plain packaging reforms instigated by Health Minister Nicola Roxon in the course of the Rudd Gillard government. People have mentioned that. It was horrifying at the time to contemplate the possibility that a multinational corporation could assert its right to be unregulated in the pursuit of profit from a product that causes death when it's used as its producer intends. And it was horrifying to think that Australia would be prevented from introducing a revolutionary new step in the global battle against what in many countries is the leading cause of preventable death through a bizarre legal process in an action brought by a foreign company. I became professionally involved with ISDS when I was elected in 2016, and I was appointed to the Joint Standing Committee on Treaties from that time. I'm now the chair of the Joint Standing Committee on Treaties. I just acknowledge, while thanking all of the people who have joined the webinar today, that Kelvin Thompson, the former member for Wills and part of that previous Labor government, is on the line, and Kelvin Thompson was a deputy chair of the JSCOT, and he's one of the Labor people who made a pretty significant contribution to our current policy positions and the things that have flowed from that. When I was elected in 2016, as Dr. Ranald will recall, one of the first agreements... Sorry, I'm just getting a bit of noise feedback. One of the first agreements that the JSCOT looked at was the Trans-Pacific Partnership, and one of the big issues for Australia was the possibility that there would then, through the TPP, there would exist between Australia and the United States an ISDS mechanism. That was avoided, but only really because the US didn't join the TPP and the CPTPP that followed. We're fortunate now to have a government that's clear in saying that Australia won't enter into agreements that includes ISDS clauses, and that we're going to work to remove ISDS clauses from agreements that are already in place. That process started back with the commitment in the Labor National Platform from 2011, and people like Kelvin were part of that. And I do want to acknowledge the sort of civil society engagement through the Labor movement and grassroots Labor Party members who have fought to achieve the commitment in the first place, and the way that now flows into the policy position of the current government. There hasn't been a more consistent advocate, though, for the avoidance and removal of ISDS provisions than AFTINET, and Pat Ranald, as everyone I'm sure participating in this webinar will acknowledge, has made an enormous contribution. She's always made sure that the JSCOT considers a substantial, well-researched, high-standard, persuasive submission in relation to every trade and investment agreement that we're looking either to enter or to amend. And she always makes time to participate in public hearings and to reinforce AFTINET's arguments in person, and that the cumulative impact of that work of Pat in person and all AFTINET who support her work is really remarkable. Already in this term, as other speakers have acknowledged, where Australia has entered into a new agreement, we've made sure that those agreements don't include ISDS clauses, and where there's been the opportunity with a new entrant like the UK to the CPTPP, we've taken the approach that New Zealand has sensibly done in the past and used side letters to ensure that there won't be those mechanisms between us and a new entrant. Right now, the JSCOT is in the process of completing our report on some amendments to the ANZFTA, the ASEAN New Zealand Australia Free Trade Agreement. And this is perhaps the first example of the second part of the commitment, which is making sure that we try to take ISDS clauses out of existing agreements. And so even the negotiations of that agreement began before the election of the Albanese government. Once we picked up those negotiations, we introduced into that process the commitment that's been agreed to establish a working party to look at ISDS, and then obviously from Australia's perspective to remove or substantially reform those provisions. So I'll just finish my remarks by noting the Clive Palmer circumstances we currently face. You know, the community, the Australian community, should understand that there is more than $300 billion worth of actions that have been levelled at Australia, and that could potentially create a kind of a liability of that scale if ZEF Investments was successful. In my personal experience, just to show the inconsistency of ISDS in the way it's pursued, and I think healthy democratic processes and policy setting approaches, just for speaking in Parliament on a couple of occasions about the ridiculousness of those actions, I have received a personal letter from Mr. Palmer suggesting that I withdraw my comments and apologise, particularly in relation to my claim that ISDS tribunals are dodgy. Needless to say, I haven't taken him up on that suggestion. And in one of the applications that one of his companies, or ZEF Investments, currently has afoot, he did use my public statements to make what's called a public remarks request in the course of the arbitration. He asked the tribunal to restrain the respondent, which is the Australian government, from making comments on the proceedings, essentially saying that what I personally was saying as a parliamentarian constituted a form of reflection on the process on behalf of the government that was improper. I'm glad to say that the tribunal didn't accept that argument and made the point that my remarks, being critical of ISDS as they may be, are an expression of Australia's constitutional democracy. That's a good thing, but frankly, it shouldn't really be in in the power of an ISDS tribunal to decide whether that is or isn't true. In my view, that is got to be a fundamental, unimpeachable foundation principle of how we operate in this country, and to have the ability for large multinational foreign companies to sue governments for healthy public policy in lots of areas, not least climate change and the energy transition, is a real risk. So I've been glad to be part of that work, as I say, in many, many cases influenced by and informed by the work of AFTINET and building on things that people in the party and the parliament, particularly Labor people like Kelvin Thompson and others, have done before me. So thanks for all of your work and all the participants who have tuned in today for having me as part of your webinar.
Many thanks, Josh, and many thanks for your ongoing work and advocacy on these issues. Our final speaker for the webinar is Kate Lappin, who's Asia Pacific Regional Secretary of Public Services International. She will discuss the impact of ISDS awards of billions of dollars on government budgets and public services in some low-income countries. Over to you, Kate.
Thanks, Julia, and thanks to all of the other speakers for the interesting presentations. I am coming from Wurundjeri country, and I acknowledge that this is unceded land. I'm going to talk about one specific case that I think really illustrates the incredibly harmful consequences of incorporating ISDS. Of course, there's many negative consequences in trade agreements that we think really impinge on the government's policy space to deliver quality public services, but ISDS is obviously the perhaps most damaging, and I'm going to focus on one particular case in Pakistan that was brought under the Australia-Pakistan bilateral investment treaty, and in fact is in many ways has similar claims as that brought by Clive Palmer, but the damage for a low-income country like Pakistan that's going through an economic crisis is perhaps even more devastating. So this particular case is one that has been in the making for many years, but the award came at a time where Pakistan, the fifth largest country in the world, was dealing with a range of multiple crises. Some of those are climate related, and there's been calls, I think even here in Australia, for a recognition that there should be reparations. In fact, large amounts of money going to countries like Pakistan that haven't caused the climate crisis but are suffering from it. But instead, the opposite is happening. Through ISDS, they have been robbed of vital resources required both to address this particular crisis, but the economic crisis that they face that has meant that there's been a number of demands, for example, to cut the already very low wages of workers who deliver public services, who are PSI members. Many of those are already barely receiving poverty wages. And another major outcome has been the push to privatise almost all state-owned enterprises and public services through the International Monetary Fund. And so these are issues that our affiliates in Pakistan are deeply concerned about and have been arguing, have been campaigning against, whilst foreign corporations are being able to dictate public policy. So this case, which is the Tienhaara versus Pakistan, or known as the Reka Dik mine, is one that has been going on, as most of the ISDS cases do, for many years. Just a little bit of a potted history here. This is one of the largest copper and gold mining deposits in the world. It's in Balochistan, which is one of the provinces in Pakistan that's close to the Afghan-Iranian border, and it's a very, very low income and difficult area. Pakistan's own mining exploration company or state-owned facility identified this deposit in the sort of 60s, 70s. But in 1993, BHP signed an exploration license, which was during the time of the caretaker government. And that license contravened a number of government laws and regulations in relation to the ownership and the management of Pakistan's resources. Now, that license was signed before the bilateral investment treaty was signed. So 5 years later, Pakistan signed a treaty with Australia that included ISDS. Pakistan was actually the first country to sign a bilateral investment treaty when it became an independent country. And those, as Pat mentioned, this is really a colonial instrument, and countries that were trying to seek investment in their case because they were newly independent sort of signed up to these in the desperate need to both find allies and investment. But in their case, then this BHP sold off their holdings to two companies, a Canadian company, Barrick Gold, and a Chilean company, Antofagasta. And once that happened, there were a number of public interest lawsuits that were lodged in the Pakistan courts for a range of reasons, but a clear one was that it had been corrupt, that there was corruption in the signing of this agreement, and that it was impoverishing the local area. And there was also the local government, the provincial government, suggesting that it would not lead to development because there was no secondary processing. For example, it was an open pit mine proposal, and that there would not be benefits. In this time, there were a lot of exploratory licenses released and not a lot of jobs or outcomes. But that same, as soon as the government rejected the next license, the exploratory license had expired, this joint venture lodged an ISDS case in 2011. Some of these cases that had already been lodged in the Pakistan courts were then found to proceeded to the Supreme Court, and the Supreme Court found that the agreement was void on the grounds of corruption. Eventually, in 2019, there were two cases held in relation to this, and together they found a breach and awarded under the provisions that Pat talked about earlier, which are very problematic, but around expropriation, for example, even though there was no actual expropriation, indirect expropriation found against Pakistan, and in total awarded them $11 billion. This is an extraordinary amount for a low-income country. It's something like 1/8 of their entire national budget. And the company, by this stage, had only invested, by their own accounts, $220 million. So this is 50 times the amount of money they had invested. Now, for a number of years, Pakistan then, in the interim years, once it was awarded between 2019 and 2022, the Pakistan government was trying to find other avenues and not have to pay out this $11 billion. You can see the amount of court cases. This is a listing of the cases that they had to go through. The legal costs for the companies alone was $60 million, and Pakistan had to pay that out. So we don't actually know how much they also had to fund in their own legal cases in all of these the particular appeals, but also a lot of procedural matters. In one of those cases, which Pakistan brought for a stay in the New York jurisdiction that deals with a number of these matters, they argued that the particular circumstances needed to be taken into account, how this would be damaging for the population amidst the COVID crisis, for example, and amidst the economic crisis with the International Monetary Fund having to provide a loan And you can see from these quotes that the court almost ridiculed the hardship that the Pakistan government was suggesting would be experienced, and said that the hardship instead was to the company, and of course denied the stay. I won't go through this, but you can see these companies, Barrick Gold has had many human rights matters that it has had in a range of countries around the world. But needless to say, this $11 billion then has had huge consequences for the government, because it is more than the loan that they had from the IMF, which is choking public services, as I mentioned. And every time Pakistan has to negotiate a new loan, it has to show what it's been doing in order to reduce its public spending. But one of the most extraordinary parts to this story is that because of the situation they find themselves in, because this is such an enormous detriment to the country, the government has now had to seek other investors in this deposit. And so they've now approached a number of countries in the Gulf countries, and Saudi Arabia in particular, to invest in this mine, and they've have to go ahead and agree with the mining companies that they will build the mine, that Pakistan will actually invest its own money in the mine. They had to pay out one of the companies $1 billion, and will use public funds for the rest. They're inviting Saudi Arabia, and in order to do that, Saudi Arabia has insisted that they sign a new trade agreement, which would also include ISDS. Pakistan, during that time, realised what a disaster it is to have ISDS in its bits, and they tried to renegotiate or withdraw from most of them, but now they're having to sign on to a new one just in order to get this mine built, so that they don't have to pay all of the $11 billion. Eventually, it's projected that they will have to pay out the $11 billion initially to one of the investors, but in the long term through investing in the mine itself. And Barrick Gold will have very little investment, but extract the lion's share, or 50% of the profits. So I think this case, but many around the world, demonstrate that Australia needs to withdraw from ISDS for our own purposes, but also for the global public good. Thanks very much.
Many thanks, Kate, and many thanks to all our speakers.